Okay, so you are ready to do it. You're launching your med spa. You've got the vision, you've got the skills, and you've even found a spot that looks absolutely perfect. But hang on, before you sign anything, we really need to talk. Because that lease agreement, it's one of the biggest decisions you're going to make. It can be the launch pad for your success, or it could be a trap just waiting to snap shut. All right, let's get into it. This really says it all. You're not just renting a space. You're not just getting four walls and a door. A lease is a long-term legal contract that literally dictates your future, your growth, your money, even the procedures you can and can't do. Think of it as the legal foundation of your entire business. If it's cracked, the whole thing can come tumbling down.
And that is the big question, right? What's actually hiding in your lease? Because let me tell you, standard commercial leases are packed with dense boilerplate language. And buried in all of that legal jargon are these little landmines, clauses that can seriously cripple your business. So today, we're going to go on a little treasure hunt, uncover those hidden dangers, and show you exactly how to protect yourself.
All right, Section 1. First things first, let's talk about protecting your actual practice. We've got to make sure your lease lets you operate and, more importantly, thrive.
I want you to just picture this for a second. It's a total nightmare. You've just spent, tens of thousands of dollars on a brand new top-of-the-line laser. You're so excited. And then you find out your lease, that permitted use clause, doesn't even allow for it. This is not just some boring legal term, folks. This one clause can torpedo your profits and completely kill your ability to bring in new, exciting treatments.
And just look at how powerful a few words can be. On one side, you have vague language like beauty or spa services. That's a huge risk. What does that even mean? A landlord could easily argue that doesn't include things like injectables or advanced microneedling. But on the other side, if your lease says medical aesthetics or non-invasive aesthetic procedures, bam, that's your safety net. That gives you the freedom to offer everything you do now and add new services down the line as technology changes.
So it's not just about the services you're allowed to offer. The building itself has to be up to code. You might find a great spot in a retail center, but what if the zoning laws there don't actually permit medical practices? You need to get it in writing from the landlord that the space complies with all the relevant medical, zoning, and building codes. The last thing you want is to get shut down because of a technicality you didn't even know about.
Okay, so let's recap the 3 absolute must-haves for protecting your practice. Think of these as your non-negotiables. Number 1, a broad medical use clause so you can offer all your services. Number 2, written proof of compliance with all the laws. And number 3, this is a big one, an exclusivity clause. Seriously, you don't want to pour your heart and soul into building your business just to have a direct competitor open up shop 2 doors down. An exclusivity clause stops that from happening.
All right, so you've protected your practice. Now, let's talk about protecting your investment, your money. This part is all about avoiding those nasty hidden costs and the personal financial risks that can really sink a new business.
Let's be real. A generic office space is not a med spa. You're going to need to do some serious work. We're talking about tenant improvements, or TIs. This is stuff like adding plumbing for sinks in every room, getting medical-grade lighting, building out private treatment rooms. The list goes on. And guess what? By default, you pay for all of it. That's why it is absolutely crucial to negotiate a TI allowance from your landlord. That's basically cash from them to help you cover those massive startup construction costs.
Okay, now for one of the sneakiest costs out there. CAM charges. CAM stands for Common Area Maintenance. It's your piece of the bill for things everyone uses, like the parking lot, landscaping, lobby. You get the idea. The problem is, these fees can go up, a lot, and without any warning. So you have to do 2 things. First, ask for a super detailed breakdown of what's included. And second, and this is so important, negotiate a cap on how much those charges can increase each year. You need predictability in your budget.
All right, listen up, because this is where things get really serious. So far, we've been talking about business expenses, but what I'm about to tell you about can leap right over your business's bank account and come after your personal assets. I'm talking about your house, your car, your savings. This right here shows you the 2 paths you can go down. The default option is an unlimited personal guarantee. That means if your business fails and can't pay the rent, the landlord can personally sue you for every penny you're worth. It's terrifying. But you can negotiate a much safer path, a limited guarantee, or a burn-off guarantee. This caps your personal risk. Maybe it's limited to just 1 year's rent. Or even better, it burns off and disappears completely after you've been a good tenant for a few years. You absolutely have to fight for this. Okay, deep breath. We've talked about protecting your practice and your money.
Now let's shift gears and talk about protecting your future. Because your business is going to grow and change, and your lease needs to be a springboard that helps you fly, not a cage that traps you.
So many people make this mistake. They only focus on the initial lease term, the first 3 or 5 years. But the real question is, what happens next? You've got to negotiate your renewal options from day one. This gives you the power to decide if you want to stay, and it locks in the terms ahead of time. Otherwise, 5 years from now, when you have a thriving business, your landlord holds all the cards and can jack up the rent to whatever they want.
So what happens when things go great? What if you're so successful you need a bigger space? Or what if you get an amazing offer to sell the business? I mean, these are the best problems to have, right? Well, your lease can turn that dream into a total nightmare. If you can't easily transfer your lease, your business is basically unsellable. You're stuck.
And this is where 2 little clauses become your absolute best friends: assignment and subletting. Assignment is just a fancy word for your right to transfer the lease to someone who buys your business. Subletting means you can rent out a room to another practitioner. But here are the magic words you need to get in your lease: that the landlord's approval cannot be unreasonably withheld. That phrase is your golden ticket to flexibility. And hey, let's not forget, you can have the best med spa in the world, but it doesn't matter if nobody can find you. Signage is so important for getting clients in the door, but landlords can be incredibly strict about it. You can't just assume you'll get a spot on the main sign. You have to get your signage rights spelled out in the lease. We're talking about the main monument sign, branding on your windows, a listing in the lobby directory. Get it all in writing.
Okay, we have covered so much ground. We've talked about protecting your practice, protecting your investment, and protecting your future. But all of this, it all boils down to one final and, honestly, most important step you can take.
I need you to really hear this. Commercial leases are written to protect one person, and one person only, the landlord. That's it. It is not a fair document. It's a one-sided contract written by their lawyers for their benefit. If you sign that standard lease without making any changes, you're essentially walking onto a battlefield and handing over your weapon before the fight even starts.
And that right there is why you absolutely need a legal partner. This isn't a luxury, it's a necessity. You need an expert, preferably someone who gets the med spa world, in your corner. They're the ones who can spot the red flags you'd never see. They can negotiate terms that actually work for your business model. They are the key to transforming that one-sided document into a lease that protects you, your investment, and your future.
So the next time you're looking at a lease agreement, I want you to ask yourself this one question. Is this document a foundation for my success, or is it a future liability just waiting to explode? Remember, pretty much everything we talked about today is negotiable. You have the power to make this work for you. Don't just sign it. Build your foundation strong. The choice and the success that follows is all yours.